Just hopping on here real quick. I've been extremely busy the last few days, so I apologize for my absence. On Wednesday, I'll be in Wyoming with the Bureau of Land Management, talking to them about patents and things of that nature. But some people have been trying to get a hold of me about cases that they have going on. I want to tell you something. Without a victim, everything is a civil case, period. They don't have a contract with you that you knowingly, willingly, and intentionally entered into, all right? So when they're alleging that it's a criminal act or a criminal charge, clarity needs to be brought for and on the official record that all the charges are, in fact, civil in nature, period, okay? And that's why you always want to ask them, is this civil or criminal? If they say it's criminal, bring forward the man or woman bringing the claim against I, alleging that I caused them harm, with firsthand perfected knowledge, okay? So where's the man or woman independently bonding the case with sworn testimony under the pains and penalties of perjury that I caused them a harm, all right? Because I'm prepared as an honorable man to provide remedy today, okay? And if they abscond from that, ignore that, you object as an appealable issue, okay? And you take exception to it as an appealable issue. The next thing to become familiar with is what an interlocutory appeal is. An interlocutory appeal is based upon your substantive rights, okay? You have a substantive right invoking the Sixth Amendment to face your accuser, not a bullshit con artist witness, okay? The witness is already discredited because he's testifying to something that he has no firsthand superior knowledge to. He didn't witness with his own eyes, okay? And so it's bullshit. Then we look at Trensley versus Pagliaro, which clearly says that no court, not even the federal court, can come to a summary judgment based upon hearsay. None of those attorneys have firsthand superior knowledge willing to testify under the pains and penalties of perjury and swear in and be cross-examined. Not a one of them. They're not going to do it because they can't. The other thing I want to touch base on real quickly, somebody called me today and said, hey, I had a lawyer laugh at me when I said I was going to get a declaratory judgment. Let me tell you something about declaratory judgments and why lawyers laugh and scoff at them, okay? The reason the lawyers laugh and scoff at declaratory judgments is because they can't get them. You want to know why? They don't have any firsthand superior knowledge where they can testify under the pains and penalties of perjury and submit an affidavit with firsthand perfected knowledge, okay? So lawyers don't get declaratory judgments. Men and women get declaratory judgments establishing the rights of the parties. And if you do your declaratory judgment properly with your notice, your private administrative process, you also in your declaratory judgment tie in your damages and what is due and owing to you with a true bill due and owing, okay? So when these lawyers are laughing and scoffing at you, understand this. They're compartmentalized like the rest of the commercial industry, okay? Most people that have a job and work for the government, quote unquote, a private for-profit corporation. And remember, when government demotes itself to working for-profit in the interest of their principal, they demote themselves to doing business in commerce, which means they're no longer government, okay? And they can sue and be sued, period. End of discussion. And the other way that you can figure that out is with a 4506A. 4506A, the court, 4506A, the prosecuting attorney, all that stuff, it'll come back. None of them are government, period. They're not tax exempt. None of them are government. So what we have going on here is them pulling the wool over our eyes because we've been asleep and lulled to sleep for so damn long, okay, that they just do whatever the hell they want. It's piracy on our land. It's Title 18, 1661 violation all day long. Okay, it's a 1983 lawsuit. It's a Title 18, 241 and 242 violations, ladies and gentlemen. And so, you know, when you do your interlocutory appeal, a lot of people like to appeal to the higher court. Don't appeal to the higher court, appeal to that court. And here's why. The first time the judge makes an egregious error or the administrator makes an egregious error, it's forgivable. It's considered a mistake, right? We all want to be forgiven for a mistake, right? We're not perfect. Some of us make mistakes. Ignorance of the law excuses no man, for all men are responsible for knowing the contracts they enter into. But we need to extend a little bit of grace. So we do an interlocutory appeal back to that same court, back to that same administrator, because if he makes that same mistake twice, okay, now it's intent. Now it's willful. Okay, now it's a crime. They're engaged in mixed war against the people of this great nation, and furthermore, against the people of the world. This isn't just a United States of America issue, ladies and gentlemen. This is global. It's an international pandemic, all right? And it's not like the scamdemic of COVID-19 or whatever. This is an international pandemic of lying, looting, pandering, thieving pieces of shit, unjustly enriching themselves, living a good life, while they send your loved ones and significant others into the Iron Hotel, if you will, into jails and prisons for profit, for gain, all right? And it's important that you guys start to ascend to the mind and realize what is really going on. With that said, I'll be back with you guys here in a couple days. I'm just getting ready to go have dinner right now as we speak. I've gotten a number of different calls pertaining to different aspects of court, and I just wanted to do this short little snippet to help you guys out. Remember, no victim, no crime. If the glove doesn't fit, you must acquit. If there isn't somebody with firsthand, superior, perfected knowledge willing to testify under the pains and penalties of perjury and independently bond the case, ladies and gentlemen, it should be dismissed immediately, for good reason and with good cause. There's no injured party. There's no plaintiff. There's no man or woman bringing a claim, thus there can be no remedy. If they're alleging that it's criminal, the simple fact remains that it's a civil matter. So it's criminal in their allegation in the first instant because it's not criminal at all. It's a civil thing. Okay? So thanks for joining me. I'll talk to you guys soon.